At trial, how do I get the doctor to actually admit in his own words that he was careless and violated the standard of care? You want to know how? And it's not by tricking him. Come join me on this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Some people think that the only way I can get a doctor to admit that he screwed up is by tricking him. Well, I want to share something with you. That is not the appropriate way to go ahead and get a doctor to voluntarily admit that he was careless and violated the basic standards of medical care. You should know that in a medical malpractice case, at trial, I have to show, number one, that your doctor was careless. I have to show that his carelessness was a cause of your injury. It doesn't have to be the cause, it only has to be a cause. And then I have to show that your injuries are significant or permanent. And all of those things have to be confirmed by a medical expert who confirms each one of those things. So now we're at trial. If I were to go ahead and ask the doctor, hey doctor, did you screw up? What do you think the doctor's going to say? His first reaction is going to be absolutely not. Of course I didn't screw up. Then he's going to turn around and say, why are you suing me? I did absolutely nothing wrong. If I were to ask the doctor at trial while on the witness stand during cross-examination, hey doctor, did you screw up? What's he going to say? He's going to say, of course not. I saved this patient's life. Now, how do you get around that? And what can I do in order to go ahead and get the doctor to voluntarily admit that he actually screwed up? Well, by coming right out and to ask him that question, even though it might be the question that's on your mind, it might be the question that's on the injured patient's mind, it might be the question that's on the jury's mind. Guess what? That is not the question to ask, and it's certainly not the way to ask it. So, what is a better way to do that? Well, one of the ways is using hypothetical questions. Now, what's a hypothetical question? You see, in these types of lawsuits, there are always factual disputes. We believe a certain set of facts occurred. The doctor disputes that. We may argue that the patient claims that she told the doctor during the particular visit about certain things, and the doctor denies that ever happening and denies recording that information. So now we have factual disputes. And the purpose of a trial really is to have the jury decide who is more believable. Are we slightly more likely right than wrong than what the defense is saying? If we are, then the jury will be required to give us a verdict in our favor, which means that they believe our version of the facts more than they believe the defense's version. Now, why is that important? It's important because if I now ask a hypothetical question, I'm asking the doctor to assume that our version of the facts are correct, just for the purposes of the question. Doctor, I understand you disagree with the facts I'm going to suggest to you, but I want you to assume for a moment that they are true, okay? Let's assume that Mrs. Jones came to you on January 1st and told you about the following problems. Would you agree that in that instance, good medical care required that you do X, Y, and Z? Now, if the doctor's straightforward, if he's straight up and honest, he has to say yes. He has to. And even if he doesn't, it's important for me to establish the contradictions showing that now he's refusing to even admit the most basic things. And ultimately, I'll have my expert on the witness stand to go through and explain to the jury why this is what you do in the following circumstances. If the patient complains of A, B, and C, now good medical care requires that you do X, Y, and Z. So, in most instances, the doctor is going to acknowledge, yes, if the patient did have those complaints, yes, good practice requires that you do X, Y, and Z. Okay, so now I'm going to add to that hypothetical question. Doctor, I want you also to assume that the patient returned to your office a week later and now had different complaints. In that instance, would you agree that good medical care required that you do the following things? And again, he has to accept and understand that yes, in that instance, even though I disagree with the facts as you explain them, yes, good care required that you do those things now. And I will continue asking those hypothetical questions. Now why? Why is this so useful? I'll tell you why. Because at the end of the trial, the jury will be asked to determine who they believe. Which version of the events is more believable? If the jury comes to the conclusion that our version of the events are slightly more likely right than wrong, then they will be required to give us a verdict in our favor. Why is that? Because now, if the jury determines that our version of the facts are correct and more believable, now the doctor has admitted in his own words, if the patient made the following complaints, good medical care required that he do X, Y, and Z. And now we will have contrasted what he did with his treatment of this patient, and now can contrast it with what good medical care is. And there are clear gaps, which means He has violated the basic standards of medical care, which means that we are entitled to a verdict in our favor. That is how you get the doctor to actually and voluntarily admit that he did something wrong. Why do I share this quick information with you? I share it with you because I wanted to explain to you exactly what happens in these medical malpractice cases here in New York. You know, I understand you're watching this because you wanted to join me on this walk around the neighborhood. Well, besides that, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.